Dear participants, dear panelists, I hope that first of all, you and your family stay safe and healthy and cope with this extraordinary situation. My name is Pascal Pichonna. I'm from the University of Fribourg, Switzerland, and as Vice President of the European Law Institute, I had the great honor and pleasure to open this European Law Institute webinar on hardship and force majeure, which follows our previous webinar of 23rd April 2020, dedicated to the ELI principles for the COVID-19 crisis. You may watch the previous and today's webinar on our website. You will find there also the subject of our next fortnight webinars, which all deal with issues related to the COVID-19 crisis and the ELI principles. Let me first begin with some instructions. We will have a first part dedicated to some short input presentations by our panelists, followed by a rough 20 minutes Q&A. We might go a bit further than 7:30, we will see. You will be able then to put your questions to us in the Q&A section. You will find it at the bottom of your window, and by clicking on it, it will open a sidebar with the chat section so that you can write your questions. We might not be able to answer all questions one by one, and so I will regroup some of them if needed and ask one or the other panelists to answer them. Tonight, we have a wonderful panel with specialists coming from very different jurisdictions. Since part of our idea is to see whether or to what extent Principle 13 of the ELI principles for the COVID-19 crisis goes beyond what is already provided for in some jurisdiction. But also we intend to see how different jurisdictions answer to similar issues linked to the COVID-19. As an introduction, I will briefly present Principle 13, and the principle will be now shared on the screen. The first, do I see it? Yeah, okay. The first subparagraph of Principle 13 is intended to be a general principle of allocation of risks following change of circumstances amounting to force majeure, impossibility, or alike due to the COVID-19 outbreak. It is meant to force the states to adapt their existing regime in a way that reflects not only the contractual provisions or the legal regime, but also the principle of good faith. And I would add of solidarity. That's why you see all these zebras, I suppose. Since the outbreak is systemic, the appraisal of the solution cannot be rigid and only driven by contractual provisions that have not anticipated such systemic impact on the contractual relationship. That is why for the ELI, the good faith and solidarity principle is so fundamental, and you find this principle of good faith expressly stated in subparagraph 1. Then the second subparagraph deals more with hardship in the sense that performance had become excessively difficult without being necessarily impossible, as in the first subparagraph. The ELI principle asks the states to ensure that, again, in accordance with the principle of good faith, parties enter into renegotiations even if this has not been provided for in their contract or by the existing legislation. The duty to renegotiate derives from the idea that given such unforeseen effect of chance circumstances on the contract, a party cannot reasonably insist on getting the performance as it was initially agreed. Again, the principle of solidarity and good faith should prevail here to share to it, share to a certain extent at least the burden of the changed circumstance. And finally, the third subparagraph states again the principle of solidarity in the allocation of risk, but by asking the states to ensure that the consequences of the disruption of contractual relationships, such as cancellation of travel arrangements, should not be at the sole risk of one party, in particular of a consumer or of SMEs. For example, in commercial lease contracts, the state should give incentives to parties to release part or all of the rent of businesses during the lockdown period. It would certainly not be compatible with the principle of solidarity or good faith to insist on the contractual terms to get the full rent for the whole period. Now, it is advisable to imagine creative solutions, such as a release now, but an option to get part of the amount released later on if the businesses are making a certain level of profit later. Romanists among you may recall the system of remitio mercedis as a kind of model for that. But of course, we already discussed these principles, and especially principle 13 2 weeks ago, so I won't begin to comment on this principle. And I think it is time now for me to pass the mic to the first panelist. The first panelist is Professor Pietro Sirena. He's Dean of the University of Bocconi in Italy and member of the ELI Executive Committee. Pietro, you have the word.
Thank you, Pascal, and good evening. And also from my side, welcome to all the attendees of this meeting. Under Italian law, the general rules on impossibility and hardship in contracts are provided for by the Codice Civile. The extraordinary measures due to the outbreak of the COVID-19 appear fundamentally consistent with such general rules, even if to a minor extent they have been adjusted or specified there in order to cope with this unprecedented emergency. With regards to first Majeure first, well, an obvious case of impossibility occurs when the performance is directly prevented by one of the emergency measures taken by the state. This may be seen to be a case of factum principis. I also resort to Roman law, as our chairman already did. So first and foremost, a case of factum principis is that of professionals that have been prevented from running their business activity so that by national authorities, so that the supply of the goods they produce or the services they render turned impossible due to a measure issued by a national authority. Under Italian law, it is undisputable that in such cases, these professionals are then excused from liability in damages. And with regard to their contract is terminated insofar as the resulting impossibility of performance is definitive. And in the sense that the other party is reasonably not interested in a delayed performance any longer. On the contrary, the Italian Codice Civile does not deal, excuse me, does not deal, I was saying, with the impossibility of the creditor to benefit from the good or from the service owed by the debtor. This is not an impossibility to perform from the side of the debtor, but it is an impossibility to benefit from the performance from the side of a creditor. Traditionally, however, under Italian law, it is acknowledged that an impossibility, this kind of impossibility of the creditor, is to be put on a par with the impossibility of the debtor to perform. So that, again, either the creditor is reasonably interested in a delayed performance, if possible, or the contract is terminated. And cases of the kind are, as an instance, those of consumers who made a reservation on trains or flights or bought all-inclusive touristic packages, and now, of course, they cannot benefit from these performances. With regard to rents and leases, on the other hand, the question that arises is that of a possible frustration of the purpose with a view to which the tenant or the lessee entered into that contract, particularly insofar as that purpose was that of running a business activity. And this point was already touched upon by our chairman, Professor Pascal Pichonat, at the outset of this meeting. As far as monetary obligations are concerned, impossibility does not generally apply in an absolute sense. However, under Italian law, it is assumed that a relative impossibility can excuse the debtor from liability, insofar as the performance of a monetary obligation would stand to bankrupt the debtor. And in relation to regular payments, such as those of taxes, banking loans, etc., the Italian legislature issued a number of specific provisions granting a moratorium. Different from Principle 12 of the ELI principle, however, it was not specified under Italian law that no interest accrue on the credit during that moratorium, not that the amount of taxes or installments subsequently due must not be increased due to that moratorium. I think that this is a gross inadequacy of Italian emergency legislation, and that to this effect, Italian legislation should be put in line with the ELI 12 principle as soon as possible. In order to keep the timetable, I must now turn quickly to hardship in contracts that is also covered by Principle 13 of the ELI principle. Albeit issued in 1942, the Italian Codice Civile does provide for the case of a change of circumstances that renders performance excessively onerous from one party, and the Italian Codice Civile stipulates that on the condition that such change of circumstances was unforeseeable at the time of the conclusion of the contract, that party can terminate the contract. However, the defendant can impede such termination insofar as it agrees to bring equity to the contractual terms. Differently from the recommendations contained in Principle 13 of the ELI principle, Italian law in force does not clearly provide for an obligation of the parties to renegotiate the contract in case of hardship, nor Italian legislation allows courts to revise the contractual terms. And therefore, my point, and this is also my conclusion, is that Italian law should be amended in this point. To that extent, Italian legislation in force lags behind the sources of transnational law that can be found in the principles of European contract law and in the UNIDROIT principles on international commercial contracts. And I think that Italian legislation should be eventually aligned with the recommendations contained in the Principle 13 of the ELI principles. Thank you.
Thank you very much, Professor Sirena. I have now the pleasure to give the floor to Professor Denis Philippe. He's professor at the University of Louvain-la-Neuve and attorney at law in Belgium, of course, and he's also the treasurer of the European Law Institute. Denis, you have the floor.
Thank you. This I have two slides. I will only deal with French law due to a lack of time, not Belgian law, and I will only deal with hardship and not force majeure. As you know, and maybe some of you does not know the case, all the French case law was based on a very important case of 6 March 1876 of the Supreme Court. I think it's important to remind the facts. By Act of 22 June 1967, this is a very old case, Adam de Craponne undertook to build and maintain a permanent canal to water the cultivated plots of the municipality of Pélissane near Aix-en-Provence. The deed provided for the construction of the canal, the inhabitants of the municipality would pay a fairly modest sum to the payable at each watering. 3 centuries later, 300 years later, the municipal authorities had recognized the inadequacy of the fees with regard to the charge borne by the heirs of Adam de Craponne. Seized of the problem in 1834, the Court of Aix considered that successive contract could be modified when the change of circumstances made it unfair. Thus, and the court accepts to multiply the fees from 15 to 60 cents. In a judgment of 31 December 73, the Court of Aix upheld the judgment, but the Supreme Court censured and broke the decision by stating that the principle of sanctity of contract governs successive contract, and in no case, however equitable the decision may appear to them, they cannot take in consideration the time and so it had been maintained during more than 1 century. And the first relief for the debtor come in 1992. It's the famous case Ouar, when the Supreme Court in France recognized the obligation to renegotiate the contract on the basis of good faith when one of the party encountered serious financial difficulties. There's a big change in 1992, but the case law remained uncertain, and that's one of the reasons why the new law of obligation in France recognized in Article 1195 the unforeseen circumstances. This new civil code was adopted by an ordinance of 10 February 2016, and it had been ratified by the Legislative Assembly on 20 April 2018. This next slide, Vanessa, please. This I will only give the main aspect of the new provision. This new provision, this new article, suppose new circumstances, what is fairly evident, and of course the corona would be such a circumstances. These circumstances must be enforceable, once more like the corona, and must be beyond the control of the parties. Same answer for the corona, and one of the parties must not bear the risk of this new circumstances. That would be the case of speculative contract. Then in speculative contract, if the price rises very sharply, it is the risk of the party who took this risk. What are the effects of this new circumstance? Excessively burdensome. This is a very limited scope of application. That means if it is excessively burdensome, the creditor cannot, on the basis of good faith, continue to claim the performance of the contract. What about the frustration of purpose? As you know, frustration of purpose is recognized in English law, like Professor Bill will mention it. This provision will not apply in case of frustration of purpose. We can take the next example. You have a license contract. The licensee can use a patent, and on a very unforeseeable basis, a new discovery rendered the patent useless. Thus, in this case, the license contract has no value and no purpose anymore. Thus, this provision will normally not apply in this case because it is not a performance excessively burdensome, it is a disappearance of the purpose of the contract. What are the effects? And that's in good harmony with our principle. The effect is that the party who suffer a prejudice can ask for renegotiation of the contract. In the meantime, this party must continue to perform the contract. If there is no success in the renegotiation in case of failures, then the party can jointly just have the option between terminating terminate the contract, or they can ask jointly by agreement to the judge to renegotiate the contract. If they could not find an agreement concerning this demand to the judge, then the case can be submitted by one of the parties to the judge, and the judge has the option or to adapt the contract or to terminate the contract. Thus you see that the effects are a bit difficult, but what is very important is that the renegotiation will always prevail, and it is, as I say, totally in harmony with our principles. Then next and last point, I just before this small, short and modest speech, I just review all the cases in France, and I see that until now there is no case where the imprévision has been applied by the court. It has been always rejected for a different reason, and but I'm sure that if there is a case with the coronavirus of excessively burdensome performance, that this provision will apply. Thank you very much, Mr. Chairman.
Thank you very much. I have now the pleasure to turn to Professor Friedrich Zoll. Professor Friedrich Zoll is professor at the Jagiellonian University Krakow in Poland and at Osnabrück University in Germany. And he is also a member of the ELI Executive Committee. Friedrich, you have the floor.
Just a moment where I can share my... Can you see my my PowerPoint or?
Yes,
yes, it's fine.
Okay, great, thank you. Thank you very much indeed, Chairman, for the invitation. I would like to speak about the Polish law, because in this amount of time it's not possible really to compare, but I would try a little bit to compare with the German law, because in this case the Polish and German system are quite close to each other, although we have a kind of different tradition in facing such kind of difficulties, and we have also a very long tradition of ad hoc legislation in case of the change of circumstances. So we have now the general rule, which we call in the traditional way rebus sic stantibus, and we are in Polish law distinguishing between the so-called big rebus sic stantibus clause and the small rebus sic stantibus clause. This latter, the second one, is applicable only to the cases of the loss of purchase value by the currency. Poland has quite long tradition, because our first rule on rebus sic stantibus, Rechtfall der Geschäftsgrundlage, taken from Germany, was actually already adopted in the year 1933 in the Polish law of obligations, where this possibility of adapt the contract or finally to resolve the contract by court was already foreseen. When we have taken this rule, when after the war in the new civil code in 1964, it has not been introduced, but of course with the change with the Polish transition in the 1989, we had it already again, and it was a rule which is quite similar in certain sense to the German Article 313, with quite essential differences, but it has this quite similar basis. And both these provisions, Polish and German, they do not invite to renegotiations of the contract. So there is not a precondition in the case of this change of circumstances, and in Polish law, the provision says only about later circumstances, so the future circumstances, not in the situation where certain situation has already existed at the time of the formation of the contract, but the parties were not aware about it. It is not foreseen in the Polish law; it is foreseen in the German law, and the Polish law requires more from the court. The adaptation, of course, it is in both systems, so must be decided by the court. The adaptation of the contract and of performance, and in Polish law there is also the resolution of the contract, the termination of the contract, which will be done also by the court. You can see here's kind of French impact, at least of this competence of the court. Even in the regular termination, we have unilateral termination without difficulties. Here, the court must decide, and this is different from the German law. The interesting point, however, is not only this system, which I think it is quite a question, but this adaptation of contract, which must be done by the court, it is a challenge because it is a very open issue question on which criteria court should follow to really to adapt the contract in the fair way, taking into account the interests of the both parties. And the court makes decision not being really a part of the process, so it is of the economic decision making process. So it is so extremely important to have this rule on the negotiation, and I think really not only our COVID principles, but the draft common frame of reference and other international drafts and sources, they could be a good source of inspiration for enforcing this pre-step of negotiation, because this is a natural mechanism of finding kind of arbitration of the price and counter performance, which is usually not so easy to find out by the court. What is interesting now in the time of coronavirus crisis is that we have again this ad hoc legislation. I was talking with this kind of Polish history. It was always as the German concept of Wegfall der Geschäftsgrundlage after the First War has been developed in the doctrine. In the Polish system, this time of this incredible inflation, it has reacted with the ad hoc legislation, with the kind of calculation of obligations. And now we have again, in the time of coronavirus outbreak, we have exactly the same kind of system. We have extremely complicated laws, which are coming every 2 weeks actually, with huge impact on existing obligation, mostly on the long-term contracts. So a lot of rental contracts has been directly affected. There is a kind of suspension of the rental contracts. Even the provision is talking about extinction, but it's not extinction because after the 30th of June, the relationship should continue. In the rental contract of large spaces, more than 2,000 meter, I guess, square meter, I guess, commercial spaces. So there is a kind of break or interruption in the relationship. Then we have, of course, a lot of rules concerning the package travel contracts on reimbursement, which is also quite interesting matter of the effect on the European law. And because my time is running out, the interesting point is, of course, about the relation of this ad hoc legislation to the general clause on a change of circumstances. To which extent this ad hoc legislation on COVID excludes the application, because of course the coronavirus legislation is somehow one-sided and does not take into account particular circumstances of the case, which is only possible at applying this general rule. And this interaction, of course, will be probably must be clarified in future by courts. It will be quite challenging issue. Thank you very much.
Thank you very much, Frederick. We can then continue now. It's time to turn to some common law system with Professor Hugh Bill, QC, professor at Oxford University, as you all know, former law commissioner of England and Wales. And Hugh, you have the words and the floor.
Sorry, I was not using it really.
Thank you very much. Well, thank you to the ELI for putting on this webinar, and thank you to Pascal for inviting me to represent the common law, if you like. As so often happens, it seems, the common, sorry, this is not moving, beg your pardon. This is not going to move. Yeah, the common law seems to be the odd person out, both in terms of our law and, at least in the UK, in terms of the kind of measures by which the government is trying to make things easier for businesses and consumers. And certainly the measures and techniques that are being used seem to be very different to what's contemplated by the Principle 13, paragraph 1 and paragraph 2. In English law, we have strict liability to perform on time. We don't have any doctrine of force majeure, and we don't have any doctrine that you can adjust the contract or have it terminated because of hardship or change of circumstances. We have, of course, a doctrine of frustration under which a contract that's become impossible will be discharged and the parties will be automatically released under the conditions I've set out on the slide, which will seem very familiar. But temporary impossibility normally will not frustrate a contract. It's only an excuse if the performance of the contract becomes impossible, for example, because performance on the date set was essential, or the impossibility lasts so long that it would make performance pointless, or performance in the new situation would be completely different to what the contract had called for, or possibly if the purpose from the point of view of both the parties has been destroyed. But otherwise, a party who doesn't perform is simply going to be in breach of contract, and it's no defense that performance is going to be far more onerous than either party could ever have imagined. How do we manage in practice? Well, of course, in practice, very many contracts actually have force majeure clauses in them. But whether a force majeure clause applies and its effect depends entirely on the wording of the clause and the rest of the contract. The clause has to be interpreted in the way that reasonable people in the same situation and with the same background information as the parties would understand it. In other words, each clause must be dealt with individually and without the help of any general doctrine that might inform the discussion. The same is true of hardship or material adverse change clauses that are sometimes found in longer-term contracts. And you can imagine that the law firms in London are very busy advising their clients on force majeure at the moment. Secondly, we do have a few particular doctrines or legislative provisions that allow a party in difficulty some relief. For example, tenants can't be evicted from their homes without a court order, and courts regularly make possession orders that are suspended as long as the tenant pays the current rent, which will often be covered by welfare benefits, and makes a small monthly payment towards the arrears. And consumers who have fallen behind on credit agreements can be given extra time in which to pay. But in most cases, relief can only be granted if the debtor probably will be able to pay at some time in the future, and meanwhile, interest continues to accrue. And then lastly, but not least, England has a relatively liberal insolvency regime. It's really quite quick to go insolvent and start all over again. Now, the new measures that are being brought in do not change contract law, and very few of them directly impact on the terms of the contracts. Mainly, they involve delaying enforcement proceedings and giving the parties more time to perform. For example, all court possession hearings were suspended for 3 months from the 27th of March, and bailiffs are no longer allowed to execute judgments for that period. But the most dramatic interventions are actually not changing the law, but imposing new regulatory requirements, in particular by our Financial Conduct Authority. Consumer credit, which includes credit given to individual traders and small partnerships. And it requires firms to comply with a number of high-level principles. One is that firms should treat customers fairly. And in the last few weeks, the FCA has ordered regulated firms to allow consumers payment holidays on many different types of credit arrangement. Firms that don't comply can be sanctioned by the FCA, and should the consumer have a dispute with the firm, the consumer's case can be taken up by the Ombudsman Service, which may also order a firm to pay out if it hasn't treated a customer fairly, even if the firm was acting within its strict legal rights. But these are only temporary measures, and their effect is limited, as interest on the debts will normally continue to accrue, though in 1 or 2 cases the interest rate has to be reviewed as well. So in contrast to, say, Germany, in England, there are very few proposals to change a law of contract or the terms of contract. Nonetheless, the UK is acting to try to mitigate the effects of COVID-19 on contracts in ways that should at least protect consumers and sole traders. But small companies seem to be left very vulnerable. It is just possible that judges will provide relief. There are a few exceptional cases, generally totally ignored in the books, in which the courts have held that a person who, for example, is too ill to work is not in breach of contract, but the other party may terminate the contract if the effects of the non-performance are serious. Sounds like force majeure. The doctrinal basis of these cases in English law is totally unclear. They seem to rest on interpretation of the particular contract. Perhaps an ingenious advocate in front of a sympathetic judge will be able to develop this into a more general form of relief. But I don't expect our courts to change our law of contracts significantly, if only because of fears over the long-term effects that might have in financial and other markets for which legal certainty and strict application of the terms agreed is considered to be important. Thank you very much.
Thank you very much, Hugh. And last but not least, now we will go more north to Scandinavian and Sweden country with Professor Kristina Rönnberg. She's professor at the University of Stockholm, Sweden, and she will give quite different insight, I'm sure. Kristina, you have the word and the floor.
Thank you. Thank you very much, Pascal and ELI, for inviting me to give a Swedish and Scandinavian perspective. In the Swedish and Scandinavian countries, we have specific rules on force majeure in our sales acts and other statutory law on specific contracts. These force majeure rules, they exempt damages as a remedy, but other remedies, such as termination, are still available. So the force majeure rules only goes to damages, exempt from damages. Since the mid-1970s, we also have a very general provision in our Contract Act on hardship due to a change in circumstances. And the prerequisites for invoking this provision on hardship, the prerequisites are very firm. So it's really only in exceptional instances that it is applicable. The perhaps special feature of Swedish and Scandinavian law is that when there is hardship, the contract or an individual term in the contract can be adjusted. So the effect is not only to the possibility to set aside a term, but the term can also be adopted to a more, well, to a different risk allocation. Now, comparing Swedish law to the ELI Principle 13, I am a little bit skeptical, particularly concerning subparagraph 2 and 3. When it comes to the liability to renegotiate, I find this a very far-reaching intervention which infringes on the freedom of contract principle. I ask myself, how can the state ensure that a party, an unwilling party, enters into renegotiations? What is the state supposed to do? Use physical force? And perhaps my biggest concern is that it is one thing to renegotiate, but what is the effect if the parties cannot reach an agreement? There is no remedy in the ELI Principle 13. So I don't understand how this subparagraph 2 is intended to operate. Is it simply as a recommendation to fully grown, commercially aware parties that it is often smarter than to cooperate by renegotiations? I guess they know this already. And if they don't, this recommendation will hardly convince them. So Swedish law does not require parties to renegotiate, but in practice, they will do so anyway. I also have some problems with the subparagraph 3 on risk allocation, which states that the risk should not be borne solely by one of the parties. To my opinion, contracts are about risk allocations. There is a great danger in changing a contractually agreed risk allocation. And we shouldn't forget that a change in an individual contract will have ripple effects on other contracts that the parties are tied to. You cannot only analyze a contract as an individual contract. You have to understand how this individual contract is interlinked with very many other contracts. And it is very often impossible to determine what the total effects are when you meddle with an individual contractual relationship. It is very easy to feel sorry for one party in an individual contract, but the picture may look very different if you consider the aggregate effects on the other party when all its customers are felt sorry for. Then very often the feeling sorry for is directed towards the other party. I find subparagraph 3 on the allocation of risks misleading and detrimental. Swedish law and Scandinavian law is based on the very firm outset that each party bears the risk of a change in circumstances. And it is only very rarely that a risk can be shifted towards, shifted to the other party. I should say in consumer law, which I find very relevant in these COVID-19 times, Sweden has very generous mandatory provisions allowing consumers to cancel contracts without having to pay any damages. So I think very many consumers are protected by these provisions. Several persons were mentioning lease contracts, and the Swedish state has introduced a scheme to provide subsidies to landlords who agrees to lower the rents. But there has been no private law provisions regarding that matter. So Sweden is in harmony with the subparagraph 1, but not subparagraphs 2 and 3. And I do not expect that Swedish law will be changed to accommodate duty to renegotiate or any general sharing of risk contrary to the contracted allocations.
Thank you, Christina. I just wanted to be sure that you were over with your presentation. Thank you to all the panelists for these input presentations. I know the time is very limited, but it gives us at least some understanding of the various perspectives. There are quite differences. Now, quite at the beginning, there was a first question. Of course, the idea is not to speak only about Principle 13, but more to see how the various systems react and whether the ideas encapsulated in Article 13 may help or not, as we have just heard now. But one question was the relation between the principle or maybe the general or the specific regulation with what the contract says or may have stated. For instance, whether when a contract says there's no revision for force majeure, no revision for hardship, whether in this specific, very special circumstance, there's a right, nevertheless, to force the parties either to renegotiate or allow the judge to embark in revisiting the contract despite that specific express clause. I know that the situation, for instance, in Swiss law, I'm not supposed to speak about Swiss law, but I'm still doing it. We would say if there's an abuse of rights, so the threshold might be higher than the good faith principle, we might be allowed to force the parties to revisit the contract. But I would be interested to see what the case is in Italy, because in Italy you have this eccessiva onerosità on one side, you have the impossibility on the other side, and maybe you react differently. Maybe Pietro, you may begin, and if there's a second panelist who want to interact, it's also possible.
Thank you,
Pietro?
Pascal.
Yeah.
Thank you very much. So first, I would like maybe to take some suggestion from the speakers of this panel, to say that to my sense, first of all, these principles are not, let's say, general recommendation for an ordinary contract law, but there are principles intended to provide from some answers to the COVID-19 crisis. So I think that we should not start with the assumption that it should be some kind of new general regulation of contract law contained in a civil code, but it's really the intention of ELI was really to cope with some disruptive effects that arise specifically from the COVID crisis. So as an instance, with regard to the paragraph 3 of the principle 13, I would not say that that should be a general rule as such. I think that it makes sense, and a lot of sense, as far as I am concerned, in this specific situation as a temporary rule intended to respond to this specific crisis we are facing. More generally, I think that as it happens, more generally, these principles provide more for substantial rules than from remedies. But this makes sense, again, because they should be shaped and adapted to each single legal system. So it is not that surprising, as an instance, that Principle 13 does not provide for a remedy in case of breach of the obligation to renegotiate, because that remedy could be, as an instance, the possibility for a court that, let's say, can adapt the contract in some systems, and in other systems it may be damages for the disadvantaged party. It may change from one system to another, but this, in my view, makes sense, as I was saying. As to your question, yes, in Italy we have in our Codice Civile some rules about impossibility, and some others about a change of circumstances that alters fundamentally the equilibrium of the contract. And to some extent, I think that this is aligned with European private law as such, because, as I was saying, if we take the PACL, or if we take the UNIDROIT principles, as we are aware of, we find there some rules that more or less are in line with Principle 13. And that, of course, impossibility and hardship can overlap, and in many cases it could be that the choice of the remedy is left to the disadvantaged party.
Thank you very much. I see that Frederick wants to say something, so maybe first Frederick, and then I will go to you, Bill, for a question, and then I come back to Denis later.
Very shortly on this question of contractual freedom, or possibility to exclude the application of the change of circumstances clause. I think this is the matter in the Polish law. It will be the matter of interpretation of this clause of exclusion of its application. So to which extent I have assumed certain risks, and very often it will be somehow as a matter of interpretation to narrow down the exclusion in order to see the risk which the parties could not assume at all would not be just covered by this exclusion, by this contractual exclusion. And I wanted only to comment very briefly on our COVID principle in ELI text. From the perspective of such system as, for example, Polish law and maybe the German law, the stress on the negotiation is a very important free market solution in certain sense, because if we have this mandatory mechanism of a change of adaptation of contract, it allows to find out the way to negotiate, and the sanction, of course, not to negotiate, is somehow taken into consideration in the case of the failure of negotiation by the adaptation of contract or deciding about the termination of contract by the court. Thank you. Oh, I cannot hear you.
Yeah, sorry. I've seen that Christina wants also to speak, but first I'd like maybe to have you answering the question that has been questioned regarding the issue about adaptation of contract and the need for consideration when you want to adapt contract. Indeed, there might be a real, even if you would say, okay, we are ready to renegotiate and adapt, would that be enforceable in the end?
Well, it's a very interesting question from Pedro del Olmo, our friend in Madrid. I think there is a link between the doctrine of consideration and the rule that if you promise to let me off some of my obligations, but I'm not doing anything extra, then that your promise is not binding for want of consideration. And the link between that and our refusal to allow renegotiation for hardship. It's simply that contract in English law is very hard-nosed. You get what you pay for, you get nothing more than you pay for, but you have to pay everything you said. That sort of approach. But I don't think there's a direct link, partly because I think the rule that you need to have fresh consideration when a contract is renegotiated is probably going to be abandoned by the Supreme Court anyway. But secondly, I think in most of these cases, at least in the UK, when a contract is renegotiated in these times, it will be because both parties think there is a way forward which will help us both. It's only when there is some joint gain that renegotiation will take place. And actually, we had Lord Neuberger on breakfast radio the other day saying that their mediation will be very important in these circumstances. But he also pointed out that there are going to be a lot of zero-sum cases where, for example, either the insurance pays out or they don't pay out. There's no sort of, it's either you're covered by insurance or you're not, and there's not going to be any room for negotiation.
Thank you very much. Denis first and then Christina. Wait, Denis, we don't hear you. Yeah, now it's okay. You can go.
Thank you. I see the question of my colleague, Professor Igna's class, and this you already answered. This application of 13.2, in case if it is expressly excluded. In the draft Belgian law of obligation, there is a possibility of exclusion. I think that it must be taken into consideration, but like my Frederick said, there are cases, even if you exclude it, you have not, when you negotiate your contract, all the circumstances. When you negotiate your contract in November 19, you had not the corona in your head. This, I think it's very important, but for me, it's difficult to exclude all possibility of renegotiation, even if it is excluded, because it's based on assumption of the contract. But I know that it is for disputable. The second question of Professor Klaas, does the type of contract not play a role? Because I think also that the type of contract can play a role. If you have a financial, long-term financial contract, maybe it will be more difficult to adapt because everything has been very carefully calculated. And it's possible that the kind of contract can have a certain role on the scope of renegotiation, of course, not on the principle itself. That's what I think. Then concerning renegotiation, the same, to answer to Christina, I think, as it was said, that the renegotiation is a respect for the freedom of the parties, because it's better to have a renegotiation because parties are free to renegotiate than to have an immediate termination of the contract. And of course, it's not certain that the renegotiation will be successful. The negotiation can fail, and in this case, it at the end of the day to a termination of the contract. And for the enforcement of the renegotiation obligation, there is a school case, Court of Appeal of Paris of 30 October 76, where the parties were forced to renegotiate with the assistance of a mediator. So thank you.
Thank you very much. But of course, the amount of damages will always be very tricky. But I give the word to Christina Rambert. Christina, sorry.
Thank you. I'm not sure that I understood your original question correctly, Pascal, but yeah. I'd like to emphasize I'd like to emphasize that according to Swedish law, it is fully possible to adopt and revise an express contractual term if it is considered unfair due to a change of circumstances. Mm-hmm. So that is possible. So it's not only implied terms that can be revised, but also express terms. And Pietro, you emphasized that we're now discussing special regulation for COVID-19 situations. And I am also always very afraid of making special regulations, because our old traditional rules, they have been slowly formed on the background of a long experience. And very often they also are able to encompass when we have a feeling that this situation, the COVID-19, is absolutely new and very, very special. Well, it is to individual contracting parties, but to the legal whole system, I am hesitant to. Well, I do believe that our old rules are able to handle also these extreme situations. Mm-hmm. But that is of course a more philosophical discussion.
But, not. It might be also very practical, I think, because if you think of the impact of looking at either a systemic approach or a more individual contract by contract perspective, using the existing elements, right? Then you might find a difficulty for courts. The question might be what happens if everyone has a very specific approach on his own very specific contract and tries to go to court, and we will have an overload of court cases at some point. So the question might also be, is there an advantage to go on a more, let's say, higher systemic level and say, okay, COVID-19 situation is such a different type, such a global perspective, that maybe contract law looked at as an individual remedy is not the appropriate way to do it. Of course, in the Scandinavian country, you use a lot ombudsman and mediator, much more, for instance, than in Switzerland or in Germany. And so maybe that's also a reason how you might use that. I'm not saying this is the case. I just put the question, and I saw that you, Bill, wanted to react to that aspect, or maybe something else.
Well, it does seem to me that we need to think very carefully about different kinds of contracts. I mean, it seems to me that consumer contracts are completely separate from the kind of big business contract that I think I and Christina probably have in mind. With consumer contracts, I think we feel relatively comfortable about saying that banks or other bodies that are dealing with consumers, even relatively small sellers, should bear the risk rather than the consumer having to do it. But I must confess that I don't actually see how you can, in practice, renegotiate large business contracts without running into the problem that Christina raised, which is if you mess with one contract, you interfere with the whole chain. And I think that's one of the reasons why English law has always set its face against contract renegotiation. And that is because they are used to dealing with very long chains of contracts. And you can't tweak it at one point without upsetting everything. The model contract we have in mind is rather different to the model which seems to inform some of the continental systems, and, forgive me, seems to inform what the ELI is suggesting in those principles.
Yeah. You're right, and this is probably also, for instance, the thematic that 15 years ago Tom Williamson spoke about when he spoke about social force majeure, and he was thinking, of course, of consumer contracts. That's correct. And of course, there's also the balance between freedom of contract and these specific remedies. There's this Giovanna Marchetti question that we have on the Q&R, which was asking whether the same problem of saving freedom of contract principle, as mentioned by Christina Ramberg, and also you build right now, exists in other systems. I would certainly say this is the case, but I see that Christina wants to say something, so you have the word.
Thank you. I would like to be very provocative in response to you. I understand that consumers should be protected. However, if we protect consumers excessively in a situation where a company's all contracts, all consumers to a company now wants to shift the risk, that which would typically may happen in a COVID-19 situation, then that company will very likely go bankrupt. And this is detrimental to the consumers and to the employees and so forth. So, I mean, we have very good consumer protection rules already. And I'm not so sure that COVID-19 is a reason to increase the consumers' rights more. I am very concerned that we once again have too much of feeling sorry for the small individual approach, and thereby don't acknowledge the needs for big business.
Mm-hmm. Your concern, in fact, was a driver force when we discussed Principle 13, subparagraph 3, which was to say the idea is not to say, oh, we will just put all the risk to the other party in consumer contracts than on the consumer, but try to have a kind of more balanced approach, saying, okay, the principle of solidarity should bring us to a kind of balance and try to find maybe new ways in order to avoid bankruptcy in chains, but also to avoid that all the gain or all the protection is made on the back of consumers. Again, one lives in a different cultural and economical background. What we see in Switzerland, for instance, is that right now most decisions are taken and the effect is really adverse for consumers most of the time. Or for instance, you fund the flight system or flight company, which is a good, important point, of course, but at the same time, there's no reimbursement for ticket for consumers. Then you would say, but these should be taken together and try to have a more balanced and solidar perspective. And so you see, of course, my feeling is of course different because what happens in my own country. But I saw that Pietro wanted to say something, so and then we will slightly, but I think we still have 5 minutes to go. But Pietro, you have to
very shortly, and sorry for being trivial, but force majeure and hardship are very general doctrines that are settled in the UNIDROIT principles on the international commercial contracts, so they have very little to do with consumer protection as such, I dare say. Another stuff, and here I completely agree with Pascal, is about paragraph 3 of these principles, as well as, if you want, the moratorium on regular payments provided for by Principle 12, or the exemption from liability for simple negligence provided for by Principle 14. This, I see them as specific measures that do have a sense with specific regard to this emergency situation and not more general. But if we take general doctrines of force majeure and hardship, I do not see how they are specifically nested in consumer protection as such.
Yeah, thank you very much. Yeah, Denis? Okay, wait. It's okay, you can speak.
Dus Professor Zwick Flesner say, it's a very good question. Picking up to Pascal reference to social force majeure, does the current crisis require a bit of trade-off between consumer-focused and business-focused results? This I think, and take as example, the voucher instead of cash refund is okay as long as voucher has cash in value or insolvency backing. This one of the message for the renegotiation and for the coronavirus principle is that we need to share the risk on a more efficient basis. So that we avoid bankruptcy for the companies, and we can also limit the effects for the consumer. And this, that's a bit our message. And the message also in this paragraph 3 of Article 13, share the risk also in case of force majeure to try to do the most to share the risk on the most efficient way.
Thank you. You spoke a lot about, you know, specific provisions compared to general contract law principles. And we see a lot of new regulations, as all of you mentioned. Now, the question I would ask as a last point, and that's Sergio Camara who puts the point, is by having all these specific legislation, of course, first of all, these are maybe temporary, but they put a lot of pressure on this harmonization of European law as well. So what would be the impact, maybe first for England, not because you have left or you are about to leave or whatever, but also because you seem to have a lot of specific rules already and added some on the top of that. What is the effect for the whole system? And then maybe you can also say something for Sergio's point.
Well, I think that we in England have been very careful to differentiate between, for example, consumers and very small businesses and everyone else. With consumers, we actually are not really allowing the sort of change that Christina is worried about. Basically, all we're doing is giving them extra time to pay. And in most cases, they will still have to pay the interest for the period when they were not paying. So it's not a terribly thorough protection for consumers, but we're keeping that very separate from the big commercial cases. And I think that's because we don't want to interfere with, you know, the notion of English law as the law for international business, when international business is thought to require very clear-cut solutions, rightly or wrongly. I'm not sure whether that's correct. What I can't do, I'm afraid, really, is to answer Sergio's question, which is, I think, about, you know, how is this going to interact with particularly full harmonization directives if we start giving consumers more rights. I assume that what will happen, and this will be a matter for you all, it won't affect us, but there will be some sort of declaration of amnesty for things done by governments during the COVID period. I can't see how else it's going to work. We're going to waste enough time on litigation over the actual disputes without having more litigation in the Court of Justice about whether member states could or could not have done something or other.
Yeah, so a kind of grace periods proclaimed by the Commission instead of because if we wait for a decision as suggested by Sergio by the Court of Justice, we might have this webinar another 5 or 10 years, and then maybe we might have a decision, because there will be so many cases coming in that it will be very difficult. Unfortunately, the time has run up. Or run out. So unless someone has something very urgent to say, I would conclude by thanking very much all the panelists for being here, for having put their thoughts to all the participants. And I'm sure that the discussion will continue online with further webinars. I know that Christina and you, Bill, will have another full day webinar on these type of issues. I forgot the date. Sorry, it's the 14th?
No, I think it's the 22nd of May.
Okay, thank you very much. So 22nd of May, if you haven't seen, you can always write to them and ask to join these webinars as well. Thank you very much. Thank you very much also to all the ELI members to attend this webinar. And I'm looking forward to the next one in 2 weeks from now, same time, same day. I wanted to say same place, but that's a bit relative. Thank you, and stay safe, and see you soon. Bye-bye. Thanks.
Bye-bye.
Thank you. Goodbye.